Good afternoon, dear students. I hope you are doing well and you are ready to listen to a lecture on the course Diplomacy and Consular Law. Our today's lecture will be devoted to such an interesting topic as establishment of consular relations. During the lecture, we will talk about such issues as the first, historical background to consular relations. Second, legal basis of the commencement and termination of consular relations. Third, establishment of a consular post, types of consular posts. Fourth, appointment of the head and members of the consular post. And fifth, the difference between an embassy and a consulate. Consular activity, like diplomatic activity of states, has a long history. Its development is connected with the intensification of trade and economic relations between the states. Consular activities are carried out primarily to protect the economic sovereignty of the state, as well as to protect the interests of individuals and legal entities of the sending state abroad. The immigration of the population, the increase in the number of mixed marriages, the strengthening of scientific and technical ties between the states have led to the fact that the activities of consular institutes are becoming extremely relevant now. The beginning of exchange of goods between people necessarily created a need for persons whose duty was to protect foreign traders coming from other areas. In ancient Greece, they were known under the name proxenos, in plural proxeni. It was equivalent for the modern term consul. In Egypt, Greek traders were protected by a magistrate acting in the capacity of judge, while in Rome, protection was the duty of praetor peregrinus. The historical roots of the institute of consulate have its origins in the city-states of Greece and Rome. It is known that the plight of foreigners in the ancient world led to the emergence of the custom of hospitality, which greatly facilitated their stay. The Greeks pledged to preserve the inviolability of the lives and property of those aliens who requested their patronage. Unlike other states, it is in Greece that private hospitality receives the status of a public institute, a custom protected by public authority. This institute emerged as a need to guarantee to a foreigner who was engaged in trade assistance and protection, because without a minimum guarantee of personal security of the merchants and the preservation of the imported goods, the trade could not develop. Foreigners began to seek the protection of honorable citizens of the city, that is proxeni. The proxeni accordingly took on a voluntary obligation to take care of the whereabouts of the visitors and, if necessary, made a request for them before the National Assembly. As a general rule, proxeni could only be nominated in accordance with the official resolution of the Council and the National Assembly of the city-state, whose interests he represented. Since the proxeni was appointed by a foreign country among the subjects of the receiving country, the sending state could not, therefore, require this person to be loyal and obedient, whereas the receiving country could apply a measure of coercion to him as to its subject. Thus, the institute of proxeni, by its scope, was close to today's honorary consular officers. For this reason, a person who has exercised significant influence and authority in his country has been appointed as a proxenos. In the Middle Ages, with the development of trade in manufactured goods, the institute of proxeni, magistrate, and praetor peregrinus were transformed into state consular representatives, whose functions, in addition to trade, were extended to include the economy in general and partly politics. This situation prevailed up until the 17th century, that is, until the appearance of diplomatic missions. In the wake of the Industrial Revolution and the development of trade on new basic principles, the Institute of Consul gained in importance once again. The first convention regulating the status of consul was concluded between France and Spain in 1769. Internal legislations related to this institute also began to take shape. For example, French Ordinance of 1781, Dutch Consular Rules of Procedure of 1786, Law on Consular Service of the United States of America of 1792. The development of the Institute of Consul was completed with the codification of consular law under the Vienna Convention on Consular Relations in 1963. So, as we can see, the institution of the Council is of a much more ancient origin than that of permanent diplomatic missions. It may be said to be a product of international trade and commerce. Even in ancient times, the merchants found it necessary to travel far and wide into foreign lands which had systems of law and custom much different from their own, and they felt the need for their disputes being settled by judges of their own choice administering their national laws. The history of the consular function is largely associated with the development of international trade and the economic interests of states. While the origins of the consular institution can be traced back to ancient Greece, it was not until the 12th century that the first figure of the consul emerged and developed to its present and more complex structure. In addition, the earliest codes on consular duties were developed throughout the same period, mostly in the form of maritime law compilations. In the 16th and 17th centuries, with the foundation of the diplomatic missions in Europe and its subsequent proliferation, a significant shift in consular powers came about, culminating with the publication of the first collection of consular rules. The extraordinary increase of consulates during the 19th and 20th centuries revealed the need for a more precise legal framework, particularly concerning the consular service and the legal status of consuls. Later on, the vertiginous changes in social, political, and economic activity, as well as the increasing global trends affecting daily life, impinged a new challenge for the consular institution: the protection of citizens and the safeguard of their interests. Some preliminary attempts at the official codification of international consular legislation resulted in the adoption of regional agreements, preceding the pioneer work carried out by the League of Nations on the subject. In spite of the League of Nations' conclusions regarding not only the desirability but the paramount importance of consular regulations through international instruments, the issue was left pending for nearly 20 years. In 1949, the United Nations International Law Commission considered the inclusion of consular intercourse and immunities as part of its future codification work. In 1963, the main international document in the sphere of consular relations was adopted. It is the Vienna Convention on Consular Relations. The United Nations Conference on Consular Relations was held in Vienna, Austria, from the 4th of March to 22nd of April 1963, and was attended by delegates of 95 states. After careful consideration of the International Law Commission's text, the final version was prepared for submission to the plenary. On the 24th of April 1963, the conference adopted and opened for signature the Vienna Convention on Consular Relations, the optional protocol concerning acquisition of nationality, and the optional protocol concerning the compulsory settlement of disputes. The convention and both optional protocols came into force on the 19th March of 1967. The Vienna Convention consists of 79 articles, most of which provide for the operation of consulates, outline the functions of consular agents, and address the privileges and immunities granted to consular officials when posted to a foreign country. A few other articles specify consular officials' duties when citizens of their country face difficulties in a foreign nation. Of particular interest for the right of individuals is Article 36, providing for certain obligations for competent authorities in the case of an arrest or detention of a foreign national, in order to guarantee the inalienable right to counsel and due process through consular notification and effective access to consular protection. Now let's move to the question concerning the establishment of consular relations and its legal basis. Under normal circumstances, the establishment of diplomatic relations includes the establishment of consular relations. Therefore, there is seldom a need to agree separately on the establishment of consular relations. However, if no diplomatic relations exist or consular relations have originally been excluded from the relationship, an agreement between the sending and the receiving state is necessary to take up consular relations. If we look at Article 2 of the Vienna Convention on Consular Relations, we can see the legal basis for the commencement of consular relations. So, Article 2 states the following. The first, the establishment of consular relations between states takes place by mutual consent. The second, the consent given to the establishment of diplomatic relations between two states implies, unless otherwise stated, consent to the establishment of consular relations. And the third, the severance of diplomatic relations shall not ipso facto involve the severance of consular relations. The expression consular relations means the relations which come into existence between two states by reason of the fact that consular functions are exercised by authorities of one state in the territory of the other. In most cases, these relations are mutual, consular functions being exercised in each of the states concerned by the authorities of the other. The establishment of these relations presupposes agreement between the states in question, and such relations are governed by international law, conventional or customary law. In addition, the legal position of consuls is governed by international law, so that by reason of this fact also a legal relationship arises between the sending state and the receiving state. Paragraph 1, which lays down a rule of customary international law, indicates that the establishment of consular relations is based on the agreement of the states concerned. This is a fundamental rule of consular law. Consular relations may be established between states which do not entertain diplomatic relations. In that case, the consular relations are the only official relations of a permanent character between the two states in question. In some cases, they merely constitute a preliminary to diplomatic relations. Where diplomatic relations exist between the states in question, the existence of diplomatic relations implies the existence of consular relations, unless the latter relations were excluded by the wish of one of the states concerned at the time of the establishment of diplomatic relations. It is in this sense that the word unless otherwise stated should be interpreted. As the first consequence of the rule laid down in paragraph 2, if one of the states between which diplomatic relations exist decides to establish a consulate in the territory of the other state, the former state has no need to conclude an agreement for the establishment of consular relations as provided in Article 2, paragraph 1, but solely an agreement respecting the establishment of the consulate as laid down in Article 4 of the Convention. This consequence is important both from the theoretical and from the practical point of view. Article 3 of the Vienna Convention on Consular Relations has also an important provision. It states that consular functions are exercised by consular posts. They are also exercised by diplomatic missions in accordance with the provisions of the present convention. The rule laid down in the present article corresponds to the general practice according to which diplomatic missions exercise consular functions. The rule in question was confirmed by Article 3, paragraph 2 of the Vienna Convention on Diplomatic Relations, 1961, which provides that nothing in the present convention shall be constructed as preventing the performance of consular functions by a diplomatic mission. It follows that in modern times, consular functions may be exercised by consulate or by diplomatic missions. If the sending state has no consulates in the receiving state, the competence of the diplomatic mission in consular affairs covers automatically the entire territory of the receiving state. If the sending state has consulates in the territory in question, the exercise of consular functions by the diplomatic mission is limited as a general rule to that part of the territory of the receiving state which is outside the consular district or districts allotted to the consulates of the sending state. Hence, only in the exceptional cases where the sending state has in the receiving state consulates whose consular districts cover the whole territory of the state in question will the diplomatic mission not exercise consular functions. But even in such cases, the sending state may reserve certain consular activities to its diplomatic mission. For example, questions of special importance or the issue of visas on diplomatic passports are sometimes reserved to the diplomatic missions in the case under discussion. According to Vienna Convention on Consular Relations, there are different types of consular posts. The first classification related to the category of the head of consular post. In accordance with paragraph 2, article 1 of the Vienna Convention on Consular Relations, consular officers are of two categories, namely career consular officers and honorary consular officers. The provisions of Chapter 2 of the present convention apply to consular posts headed by career consular officers. The provisions of Chapter 3 govern consular posts headed by honorary consular officers. So, according to this classification, there are two types of consular posts. The first is a consulate and the second is a honorary consulate. About honorary consulate we will talk on the next lecture. The next classification is according to rank of the head of consular post. Article 9 of the Vienna Convention on Consular Relations states that heads of consular posts are divided into four classes, namely consuls general, consuls, vice-consuls, and consular agents. According to this classification, there are four types of consular posts regarding the class of the person which is the head of this post. It could be consulate general, consulate, vice-consulate, and consular agency. But in most cases, states establish consulate or consulate general. Our next question is the establishment of a consular post. Consular relations can be maintained without setting up consular posts. When the consular section of the embassy takes care of all consular matters coming up in the receiving country, a separate consular post is unnecessary. When a sending state, however, wants to establish a consular post, it needs the consent of the receiving state, particularly with regard to the seat, the classification, and the consular district. And it is regulated by Article 4 of the Vienna Convention. The consent is implicitly contained in the exequatur granted by the receiving state. Thus, it is finally the receiving state that decides whether and how a consular post may be established. Often the seat and district of the consulate are controversial. Some countries have made it clear that they will not accept the establishment of a consulate everywhere on their territory. For example, the United States government has published a checklist by which it tries to find out whether there is a genuine need for a consular post. Germany insists that districts of foreign consulates comprise one or more states of the Federation. Australia insists that the request to establish a consular post should address the projected scope and volume of the workload of the new post. The United Kingdom German Consular Treaty contains a generous most favored nations clause. It allows in Article 2 the establishment of consulates at any place where any third state possesses a consulate. Well-known and important cities like Marseille in France or Los Angeles in the United States have many consulates. Article 4 of the Vienna Convention on Consular Relations tells us the main points concerning the establishment of a consular post. The first is that the consular post may be established in the territory of the receiving state only with the state's consent. The second, the seat of the consular post, its classification, and the consular district shall be established by the sending state and shall be subject to the approval of the receiving state. Third, Subsequent changes in the seat of the consular post, its classification, or the consular district may be made by the sender state only with the consent of the receiving state. Fourth, the consent of the receiving state shall also be required if a consulate general or a consulate desires to open a vice consulate or a consular agency in a locality other than that in which it is itself established. And the fifth, the prior express consent of the receiving state shall also be required for the opening of an office forming part of an existing consular post elsewhere than at the seat thereof. So, paragraph 1 of this article lays down the rule that the consent of the receiving state is essential for the establishment of any consulate, whether it is consulate general, consulate, vice consulate, or consular agency in its territory. The principle derives from the sovereign authority whichever state exercises over its territory and applies both in those cases where the consulate is established at the time when the consular relations are established and in those cases where the consulate is to be established later. In the former case, the consent of the receiving state to the establishment of a consulate will usually already have been given in the agreement for the establishment of consular relations. But it may also happen that this agreement is confined to the establishment of consular relations and that the establishment of the consulate is reserved for later agreement. An agreement on the establishment of a consulate presupposes that the states concluding it agree on the boundaries of the consular district and on the seat of the consulate. It sometimes happens in practice that the agreement on the seat of the consulate is concluded before the two states have agreed on the boundaries of the consular district. The agreement respecting the seat of the consulate and the consular district will, as a general rule, be an express agreement. Nevertheless, it may also be concluded tacitly. The consular district, also sometimes called the consular region, determines the territorial limits within which the consulate is authorized to exercise its functions with respect to the receiving state. Nevertheless, in the case of any matter within its competence, it may also apply to the authorities of the receiving state which are outside its district insofar as this is allowed by the present articles or by the international agreements applicable in the matter. The United Nations International Law Commission has not thought it necessary to write into Article 4 the conditions under which an agreement for the establishment of a consulate may be amended. It has merely stated in paragraph 3, in order to protect the interests of the receiving state, that the sending state may not change the seat of the consulate or the consular district without the consent of the receiving state. The silence of the article as to the powers of the receiving state must not be taken to mean that this state would always be entitled to change the consular district or the seat of the consulate unilaterally. The Commission thought, however, that in exceptional circumstances the receiving state had the right to request the sending state to change the seat of the consulate or the consular district. The sole purpose of paragraph 3 is to govern any changes that may be made with respect to the seat of the consulate or the consular district. It does not restrict the right of the sending state to close its consulate temporarily or permanently if it so desires. Paragraph 4 applies to cases where the consulate, having already been established, desires to open a vice consulate or consular agency within the boundaries of its district. Under the municipal law of some countries, the consuls general and the consuls have authority to appoint vice consuls or consular agents. Under this authority, the consuls general and the consuls may establish new consular posts on the territory of the receiving state. It has therefore been necessary to provide that the consent of the receiving state is required even in those cases. The Convention on Consular Relations adopts the idea of multiple accreditation of the Vienna Convention on Diplomatic Relations. Article 7 of the Vienna Convention on Consular Relations allows that one consul exercises functions in two or more states, and Article 18 of the Vienna Convention on Consular Relations permits that two or more states appoint the same person as their consul. The states concerned have to agree about this. The first alternative is important in case a diplomatic mission is double accredited because it allows its consular section to be active in both states. The second alternative is unpopular with receiving states, particularly if various states try to appoint the same person as their honorary consul. Under extraordinary circumstances, it happens, however, that a state takes care of the consular interests of another state. Sweden, for example, protects the consular interests of the United States in North Korea. Even without being explicitly appointed, a consular post may act on behalf of another state, provided the receiving state has been notified and agrees. It is Article 8 of the Vienna Convention on Consular Relations. This provision is important for European Union member countries because, according to Article 20 of the Treaty on the Functioning of the European Union, diplomatic missions and consular posts of the European Union member states in a third country have to give protection to nationals of the European Union states that are not represented in that country. In practice, consulates are typically headed by a consul general or a consul and are called consulate general or consulate respectively. It is also possible that a consular post is headed either by a vice consul or a consular agent. It's according to the Article 9 of the Vienna Convention, but this seldom happens. Consular agents are private persons who make a living from a different occupation in the receiving country. They are honorary appointments and thus enjoy status similar to that of an honorary consul. The main information about the appointment of the head of the consular post we could find in Articles 10, 11, and 12 of the Vienna Convention on Consular Relations. Article 11 of the Vienna Convention declares that the head of a consular post shall be provided by the sending state with a document in the form of a commission or similar instrument made out for each appointment, certifying his capacity and showing, as a general rule, his full name, his category and class, the consular district, and the seat of the consular post. The sending state shall transmit the commission or similar instrument through the diplomatic or other appropriate channel to the government of the state in whose territory the head of a consular post is to exercise his functions. If the receiving state agrees, the sending state may, instead of a commission or similar instrument, send to the receiving state a notification containing the particulars required by paragraph 1 of this article. As a general rule, the head of a consular post is furnished with an official document known as consular commission. Vice consuls and consular agents are furnished with a similar instrument which bears a different name, for example, decree, patent, or license. For purposes of simplification, Article 11 uses the expression consular commission to describe the official documents of heads of consular posts of all classes. While it may be proper to describe differently the full powers given to consular officials not appointed by the central authorities of the state, the legal significance of these documents from the point of view of international law is the same. While the form of the consular commission remains nonetheless governed by domestic law, paragraph 1 of the article states the particulars which should be shown in any consular commission in order that the receiving state may be able to determine clearly the powers and legal status of the consul. That is, full name of the consul, his category and class, the consular district, and the seat of the consular post. The expression as a general rule indicates expressly that this is a provision the non-observance of which does not have the effect of nullifying the consular commission. The same paragraph specifies, in keeping with practice, that the consular commission must be made out in respect of each appointment. Accordingly, if a consul is appointed to another post, a consular commission must be made out for that appointment, even if the post is in the territory of the same state. Another consular commission will also be necessary if the head of post receives promotion and the rank of the consular post is raised simultaneously. In the practice of some states, the head of a consular post is even supplied with a new consular commission if the consular district is altered or the location of the consulate is moved. The consular commission, together with the exequatur, we will talk about it a little bit later, is retained by the consul. It constitutes an important document which he can make use of at any time with the authorities of his district as evidence of his official position. If we compare consular relations with diplomatic relations, we can say that consular commission is almost similar to credential of the head of diplomatic mission, and exequatur is close to agreement in diplomatic law. According to Article 12 of the Vienna Convention, the head of a consular post is admitted to the exercise of his functions by any authorization from the receiving state termed an exequatur, whatever the form of this authorization. A state which refuses to grant an exequatur is not obliged to give to the sending state reasons for such refusal. Subject to the provisions of Article 13 and 15, the head of a consular post shall not enter upon his duties until he has received an exequatur. The exequatur is the act whereby the receiving state grants the foreign consul final admission, and thereby confers upon him the right to exercise his consular functions. The same term also serves to describe the document by which the head of post is admitted to the exercise of his functions. In accordance with the general practice of states, it is the domestic law of each state which determines the organ competent to grant the exequatur. In many states, the exequatur is granted by the head of the state if the consular commission is signed by the head of the sending state and by the Minister for Foreign Affairs in other cases. In many states, the exequatur is always granted by the Minister for Foreign Affairs. In certain countries, competence to grant the exequatur is reserved to the government. As is evident from Article 12, the form of the exequatur is likewise governed by the municipal law of the receiving state. As a consequence, it varies considerably. According to the information at the Commission's disposal, the types of exequatur most frequently found in practice are the following. So, exequaturs may be granted in the form of a decree by the head of the state, signed by him and countersigned by the Minister for Foreign Affairs, the original being issued to the head of consular post. Second is a decree signed as above, but only a copy of which, certified by the Minister for Foreign Affairs, is issued to the head of consular post. The third, a transcription endorsed on the consular commission, a method which may itself have several variants. And the last, a notification to the sending state through the diplomatic channel. The term exequatur is used in these articles to denote any final authorization granted by the receiving state to a head of consular post, whatever the form of such authorization. The reason is that the form is not per se a sufficient criterion for differentiating between acts which have the same purpose and the same legal significance. Inasmuch as subsequent articles provide that the head of a consular post may obtain provisional admission before obtaining the exequatur, or may be allowed to act as temporary head of post in the cases referred to in Article 15. The scope of the article is limited by an express reference to these two articles. The grant of the exequatur to a consul appointed as head of a consular post cover ipso jure the members of the consular staff working under his orders and responsibility. It is therefore not necessary for consular officials who are not heads of post to present consular commissions and obtain an exequatur. Notification by the head of a consular post to the competent authorities of the receiving state suffices to admit them to the benefit of the present articles and of the relevant agreements in force. However, if the sending state wishes in addition to obtain an exequatur for one or more consular officials who are not heads of post, there is nothing to prevent it from making a request accordingly. Since the head of a consular post is often working in a zone where the interests and sometimes the legal systems of his and the host country collide, he needs a commission from the sending country and an authorization called, as you can already know, exequatur from the receiving country. Because heads of consulates change frequently, their appointment and admission are dealt with in a business-like manner. After the foreign ministry has decided whom to send as head of a particular consular post, his commission of appointment will be drawn up. It gives the consul's name, his rank, his consular district, and the seat of his post, and describes his functions. In many countries, the commission is signed by the head of state and the foreign minister. This commission is sent to the sending country's embassy that forwards its verbal note to the foreign ministry of the host country asking to issue the exequatur for the appointee. Sometimes, in accordance with Article 13 of the Vienna Convention on Consular Relations, an embassy might request the granting of a provisional admission. The foreign ministry of the host country informs the embassy by verbal note of the concurrence of its government to the appointment. The consul can now take up his functions. The receiving government, often through an official document signed by the head of state and the foreign minister, requires, complying with Article 14 of the Convention, that the competent authorities of the receiving state do receive, countenance, and, as there may be occasion, favorably assist the new consul. If the receiving state refuses to grant the exequatur, it is not obliged to give reasons. The same is true when a receiving state declares a consular officer persona non grata. These provisions follow the relevant provisions of the Convention on Diplomatic Relations. For example, when the Turkish government refused to grant a new Bulgarian consul in Edirne an exequatur in the fall of 2000, it, however, published the reason. It was a reprisal declaring the Turkish consul in Burgas persona non grata. And by the way, when we are talking about persona non grata, we should remember provisions of Article 23 of the Vienna Convention on Consular Relations, which declares the following. The receiving state may at any time notify the sending state that a consular officer is persona non grata or that any other member of the consular staff is not acceptable. In that event, the sending state shall, as the case may be, either recall the person concerned or terminate his functions with a consular post. If the sending state refuses or fails within a reasonable time to carry out its obligations under paragraph 1 of this article, the receiving state may, as the case may be, either withdraw the exequatur from the person concerned or cease to consider him as a member of the consular staff. A person appointed as a member of consular post may be declared unacceptable before arriving in the territory of the receiving state or, if already in the receiving state, before entering on his duties with the consular post. In any such cases, the sending state shall withdraw his appointment. And now let's talk about the difference between an embassy and a consulate. A consulate or consular post is a form of external relation body which is situated outside the country in charge of matters related to individual people and businesses, in other words, issues outside intergovernmental diplomacy. Responsibilities of a consulate include protecting the interests of their citizens in temporary or permanent residence in the host country, issuing passports, issuing visas to foreigners, and public diplomacy. However, the principal role of a consulate lies historically in promoting trade, assisting companies to invest and to import and export goods and services both inwardly to their home country and outward to their host country. So the main differences between embassy and consulate are the following. Embassy and consulate refer to government representation in a foreign country. A country will have only one embassy in another state, whereas it will have a number of consulates in various cities. The next is that an embassy is a larger representation, but a consulate is only a smaller version of the embassy. Consulates, in a sense, can be called junior embassies. Embassies are permanent diplomatic missions generally located in a country's capital. Consulates are located in big cities and not in the capital city. Countries establish embassies in another nation only if it recognizes the sovereignty of that country. While ambassadors, who are high-ranking diplomatic representatives of a country, represent the embassy, consuls represent the consulates. So, embassy is headed by ambassador and consulate is headed by consul. The fourth difference is that ambassadors are the spokesperson of their government. Embassies have a broader role to play and they represent their government in another nation. So, embassies mainly deal with political and diplomatic relations with the host nations. The embassy also look after the welfare of citizens who are living in that country. When embassies deal with major diplomatic tasks, consulates deal with minor diplomatic tasks. The number of consulates depends on the requirement. The main task of consulates is to foster trade and maintain commercial links between the two countries. Moreover, the consulates handle issues related to visas, passports, and also handle tourists and expatriates. So it deals mainly with economic, social issues, safety of its citizens. The major role of the consulate is promoting trade, like helping companies in the host nation to invest in its country and vice versa. It also facilitates import and export between the two countries. While embassy is a diplomatic representation of a government in another nation, consulate is a representation of public administration. Embassies exchange messages between its government and the host government. Consulates are only responsible for its own citizens who are traveling or living in the host nation. The embassies inform its government about all important social, political, military, economical, and other events happening in the host nation, whereas consulates report about births, deaths, marriages, and other events to its government. And the last difference is that embassies are also responsible for preparing treaties between the two nations and also in arranging official visits. The consulates are also responsible for informing its citizens about all security issues. Consulates are also entrusted with the responsibility of looking after its citizens in case of detention or arrest. Though both embassies and consulates represent its government in a foreign country, they have totally different responsibilities and different roles to play. It must be noted that termination of diplomatic relations between states usually entails the termination of the diplomatic mission, but consular relations between countries remain like that. And the last thing I want to mention is the main conditions for termination of the functions of a consular post. Article 25 of the Vienna Convention on Consular Relations declares the following. The functions of a member of a consular post shall come to an end inter alia on notification by the sending state to the receiving state that his functions have come to an end, on withdrawal of the exequatur, on notification by the receiving state to the sending state that the receiving state has ceased to consider him as a member of the consular staff. This article deals with the modes of termination of the functions of the members of the consulate. The enumeration is not exhaustive and it contains only the most common causes. The functions may also be terminated by other events. For example, the death of the consular official or employee, the closure of the consulate, or the severance of consular relations, the extinction of the sending state, the incorporation of the consular district into another state. The events terminating the functions of a member of the consulate are sometimes set out in consular convention between two states. In Article 26 of the Vienna Convention on Consular Relations, an important provision is stated which tells us that the receiving state shall, even in case of armed conflict, grant to members of the consular post and members of the private staff, other than nationals of the receiving state, and to members of their families, forming part of their households, irrespective of nationality, the necessary time and facilities to enable them to prepare their departure and to leave at the earliest possible moment after the termination of the functions of the members concerned. In particular, it shall, in case of need, place at their disposal the necessary means of transport for themselves and their property, other than property acquired in the receiving state, the export of which is prohibited at the time of departure. This article corresponds to and is modeled on Article 44 of the Vienna Convention on Diplomatic Relations. The expression "at the earliest possible moment" should be construed as meaning, first, that the receiving state should allow the persons covered by this article to leave its territory as soon as they are ready to leave, and secondly, that it should allow them the necessary time for preparing their departure and arranging for the transport of their property. So this was the main information concerning the topic of our today's lecture. Thank you for your attention.